to submit, in Bennett Coleman, the Supreme Court expounded that the right to freedom of press can be taken away quantitatively too. In a country where 68% of the Indian population consumes information online, as per research on English news readers by
I'm sorry, I need to interrupt just for a second. We've read
yes,
the
Your Lordship.
memorial, so we know the basic outline of your arguments. It would be
Yes,
better
Your
if you can first just draw the reference as to how it is not a reasonable restriction as it is provided in the Constitution, that there can be reasonable restrictions to rights under Article 19. So if you can just clarify that and then move on to the contention, it will make everything easier.
Your Lordship, the reasonable restrictions as per as they are imposed in the Beverly Hills.
Yes.
So in Anuradha Bhasin case, it was reiterated the two-pronged test of proportionality vis-a-vis internet shutdowns. The heavy reliance was relayed on the less intrusive methods of using communication blackouts. This is inconsistent. This is consistent with the K.S. Puttaswamy judgment, which also laid down the proportionality judgment, where necessity stage, the least restrictive measure, and the balancing stage, which talks about the least disproportionate damage to the right holder, were a part of the proportionality test. Keeping in consideration these points, any test needs to be merited by a strong reason, and the measure used should be, should be least restrictive. Considering the aforementioned points, the petitioner submits that the government of Avocado has not used the least restrictive measures for controlling an apprehension of a law and order situation. To substantiate the claim, I would focus on the kind of restrictions that were imposed on the people. So the internet shutdowns were of blanket nature. The internet shutdowns were total shutdowns when there are options of selective shutdowns, which were seen after Anuradha Bhasin judgment that the government has the capability of imposing selective shutdowns, but it didn't. And even in Anuradha Bhasin, the Solicitor General also said that we don't have the capability to the technological capability to impose selective ban on internet. Instead of that, an internet shutdown, a total internet shutdown, is needed, which
No,
is
that's
which
still
will
the
be.
arbiter. I'm sorry, that's still the arbiter. Let's just stick to the ratio the judgment relies on. No? Let's not discuss the ASG's arguments. That won't help us.
No, Your Lordship, I am just trying to substantiate my claim of whether the least restrictive measures were used or not.
Carry
Uh,
on.
Thank you, Your Lordship. Uh, this clearly establishes capability of less intrusive methods of curbing the internet over a period of time. This calls for a conclusion that blanket internet shutdowns are inherently disproportionate, since there always exists a less intrusive method of curbing the right. Internationally, this method is called selective ban, as I just mentioned. An important observation here is that even white listing does not treat access to information as fundamental rights, as expounded in ADR versus Union of India. So what whitelisting is that selective sites are selected for access. Even in this, the fundamental rights are exercised as an exception, and rights are the exception here. And the non-access to these sites is the rule. So that is what this particular whitelisting establishes, which is right now in place. The proportionality test fails vis-a-vis internet shutdowns or even whitelisting, as most common reasons for such ban is rumor mongering or incitement of violence, which remains to be unseen post Anuradha Bhasin caused relaxations. Proportionality also failed when we consider that terrorism has been reduced as per government data after 2000, the
Mr.
year
Counsel,
in which internet. Yes, Your Lordship.
Mr. Counsel, you are aware that the issue you are countering here is whether the freedom of speech and expression and freedom of internet is a part of fundamental right or not. The answer you are
Uh,
saying
you,
it is yes. So just explain, give me reasons that why do you think that freedom of internet is an essential fundamental right? First clarify this issue,
Your
then we
Lordship,
will move on to the other issues. First clarify this issue. You have still not clarified
Your Lordship,
why do you think that freedom of internet is an essential fundamental right?
Your Lordship, so sorry for digressing. The the other Lordship asked me whether the restrictions are proportional or not, and that is why I moved on to this topic. I would surely,
Yes, please go ahead, please.
yes, I would go ahead with the first submission. Your Lordship, as I already clarified, that Article 19(1)(a) does uh, the right to access to internet does come under Article 19 Clause 1 Subclause A. Declaring freedom over internet or right to access to internet as fundamental right is also consistent with global developing jurisprudence, as also in Article 19 of Universal Declaration of Human Rights. In the concluding lines, through any media, I quote, through any media and regardless of frontiers, contemplates the use of internet for the use of media. There have been several judgments, as you can see in point 1.3 in the fourth page of my submissions, that several constitutional courts and Greece's constitution has also recognized information, information access
Yes,
through
yes, we are aware
internet
of that.
as a fundamental right.
Okay,
Moving on from this,
I'm sorry, I just need to interrupt for a second. My brother just was trying to take you to the point where we are aware that right to internet is a corollary of your Article 19. We don't deny it. What we are trying to
yes,
understand is Article 19 also allows you to have reasonable restrictions. Tell us as to how this fundamental right cannot be reasonably restricted when we have such a scenario in place. And that will answer your first contention as a whole.
Your Lordship, the first contention specifically talks about freedom of speech over the internet. And as constitutional philosophy is developing, no right is seen as, completely, what do you call it, absolute. And when
Exactly.
there is no absolution of rights, there are tests put in place which do, ensure that such rights, if are taken away from people, they are taken away with reasonable restrictions. And these reasonable restrictions are is what needs to be contemplated when we are taking away such rights. As I mentioned earlier, taking away of rights should be an exception, and that is why it should be treated as an exception. When I talk about freedom, right to access to internet as a fundamental right, I am not saying that this should be an absolute right and everyone should be given access to the internet. It can be taken away, but how it should be taken away should be established with the clearest of procedure and with reasoned orders.
Okay, we get it. Now let's come down to point number 2, the issue number 2.
Your Lordship, the issue number 2 is whether the law and order situation justify the communication blackout.
Mr. Counsel, you only have 5
As
minutes left.
Okay, Your Lordship, I would come down to my point number. Okay, so Your Lordship, I have already discussed about how the least intrusive method is not being used in Jammu and in Beverly Hills. I'm so sorry, and this also makes this fails the proportionality test as contemplated by the judiciary of India, judiciary of avocado. The bans imposed in Beverly Hills also constitute as a hate crime. This can be substantiated by the fact that there exists digital discrimination. Recent research recognizes digital discrimination in access to communication technology as a global trend that strongly affects disenfranchised ethnic groups. I substantiate this claim with, in a state where 55.72% of the people are suffering from depression, the state imposes measures like communication blackouts, it only exacerbates the problem. The pattern of discrimination arises when we analyze a report which was published by SFLC that listed internet shutdowns pan India from 2013 to 2018. Out of 172 orders, 79 were specifically for Beverly Hills, which accounts for 45.9% of the total. And the quantum of time was the largest in Beverly Hills too, which is highly disproportional to the internet shutdowns which were put in place in other particular states. Moving on to issue 3, whether the mere suspicion is enough to impose restrictions on movement under section 144. The orders issued under section 144 are contrary to law as they do not fulfill the various guidelines laid under section 144 as to when it is to be applied. The Supreme Court in Madhulimaya versus subdivisional magistrate stated that it is obvious that emergency must be sudden and consequences sufficiently grave. I would like to ask the respondent that where was the emergency sufficiently grave as to apply the curfew measures on the 12th of April before even a law came in which would satisfy a public emergency. I would also like to substantiate that public emergencies becomes an almost redundant category, something clearly beyond the expectation of the legislature. For public safety to have any teeth, therefore, it must refer to a specific situation of identifiable danger. So there wasn't any identifiable danger in the state of Beverly Hills at that particular point of time when such measures were imposed. I would also like to substantiate this claim in the various reasonable measures that have been laid down for section 144. The orders, the first point is the orders need to be placed when there is an imminent emergency. As I explained, this particular part has been failed. B is power under section 144 of CRPC cannot be used to suppress legitimate expression of opinion or grievance or exercise of any democratic rights. I would also like to ask the respondent that when section 144 is imposed with a total communication blackout, and even the media houses have come to the courts to impose for the practice of their fundamental rights, how is it not used for suppressing legitimate expression, as no one can really express in such situation, neither by movement, nor by words, nor by any other means used through internet or any other source. The third point is the power should be exercised in a bona fide and reasonable manner. I would substantiate this later, that how they are failing this claim. The fourth point is, while exercising the power under section 144 CRPC, the magistrate is duty bound to balance the rights and restrictions based on principles of proportionality. As I have already substantiated, the principles of proportionality have been failed here as least restrictive measures aren't used. The fifth point is repetitive orders under section 144 CRPC would be an abuse of power. To substantiate this claim, I would say that repetitive bans have been seen in this particular area. And right now, the ban put in place is a blanket ban on every kind of communication or movement. Such ban on communication and movement is also a testament of maleficence of the administrative, as there existed no emergency on 12th of April to establish such orders. It can also, to establish such, I would rephrase myself, to establish such, Your Lordship, I just have 2 more submissions if you would grant me some.
Do you need?
Just 2 minutes, Your Lordship.
Okay.
Not more than 2 minutes. Much obliged, Your Lordship. The point of separation of legitimate expression, yes, I'm so sorry, Your Lordship. This establishes a maleficence of the administration, as there existed no emergency on the 12th of April. It can also be seen that the orders are vague and the lack of application, and there is a lack of application of mind, as mere terms used as vague terms like incitement of violence is apprehended are used. The point of separation of legitimate expression of opinion is of vital importance here, as what accompanies orders of section 144 is a gag on the media and internet shutdowns, which effectively hurdles legitimate expression. Babulal Parathe versus State of Maharashtra that argued to argue that restrictions can be imposed on all person, it is respectfully submitted that the case of Babulal Parathe does not lay down a general proposition that the state can impose blanket restrictions. It always lays down a test which I have mentioned uh, in the submissions. Moreover, a case in respect of Section 144 cannot be used to append decades of free speech jurisprudence under Article 19, which makes it clear that the state cannot impose overboard restrictions that's that hinder speech, and that is, the overboard restrictions that are harmful and does not lead and lead and restrictions that are not really directly connected with the incitement of violence. In the point 4, whether restrictions imposed on Beverly Hills are reasonable as contemplated in the Constitution of Republic of Avocado, I would like to submit that it also infringes the right to health, as we can see in the current petition in the Supreme Court, where 4G rights are being demanded. It is due to the situation that has been created in the world right now, that right to health has become accessible only through the internet. Right to health has, Your Lordship, am I audible?
Yes, yes, please go ahead.
Right to health has only become accessible through the internet. So is the right to education, which is a positive right, which needs to be enforced by the government for students below the 8th standard. These particular rights are also infringed when we take away the right of internet from the people, or we impose curfews, blanket curfews under Section 144, which do not really have the the purity which is established by due procedure of law under Article 21. Your Lordship, I would like to end my submissions with a prayer. Wherefore, in the light of the issues raised, arguments advanced, and authorities cited, it is humbly prayed that the Honorable Court first declare the access to internet a fundamental right under Article 19, 21, and 21A. Order the communication ban in Beverly Hills ultra-wires owing to its unconstitutionality. Issue guidelines or directives curbing the use of internet shutdown in the light of excessive use of the same. Order the blanket restriction imposed under Section 144 to be removed from Beverly Hills as being overboard ultra wires. Issue orders to set up a review committee which will review all the orders passed in Beverly Hills and form a report on the same matter. Your Lordship, pass any order that it seems fit in the interest of justice, equity, and good conscience. Thank you, Your Lordship.
Counsel, I just have one question. Your first prayer says declare access to internet a fundamental under Article 19, 21, and 21A. Isn't it already been declared under K. Pattaswamy? You just want us to declare it again?
Your Lordship, access to internet has not been contemplated, and this was also talked about by Justice N.V. Ramana and Anuradha Basheen. He said that right to access of internet has not been contemplated by the petitioners, and that is why we are not perusing over such a right. It is as per my understanding, it is right to access to internet is not really made a fundamental right, and only the protection of free speech over internet has been given by the Article 19, and the protection of privacy has been given over the internet. It is not really the access to internet which is given a priority here. It is the use over the internet and how your use is protected online. This is in consonance with a UN directive which was released in 2016, which said all the offline rights are to be transferred to are to be the same on an online medium. But what right to access to internet contemplates is that access to internet should be the first priority, and then the rights protected over internet should be the further priorities.
Okay, I have one more question, and then I let my brother judge ask you a few.
Yes,
my second question was you've kept mentioning Anuradha Basheen, and you really want to rely on that judgment because it favors your proposition. However, Anuradha Basheen although did make remarks stating that such bans should not be made, such blanket bans should not be allowed. However, they never struck it down. The Supreme Court did not actually go ahead and
Your
strike
Lordship,
down, if I may complete, did
yes,
not
yes,
actually
I'm so sorry, Your Lordship.
go ahead and strike it down. They in fact just told that the future orders or notifications or guidelines passed by the government should have more reasoned decisions for the same. So is that all that you are seeking from us also while relying on the judgment, that you just want us to direct the respondents, which is the government, to pass more reasoned orders and continue such bans?
No, Your Lordship. The peculiar thing about Anuradha Basheen was that the government rejected or did not really show all the orders that were put in place to put such curbs on freedom. When such decisions are put in place, they can be challenged in court of laws in the first place. Any human right lawyer or any lawyer with good conscience can go and order a decision. But what if a decision does not even exist? See, right now there should be a check and balance relationship between such orders. Such orders in the first place are not.
I'm distinguishing your prayer from another Bashin. Just prove it to me as to how they both are similar, as to how you can rely on that judgment, because that judgment doesn't strike down any internet ban orders. It
Yes, Your
just says
Lordship,
that
it was.
orders should be provided. So you relying on the same lets us follow the path that the Supreme Court has already laid down under other Bashin. And it will not actually answer your prayer. Now you can carry
Your
on.
Lordship, I would like to go the extra mile that is needed in the particular judicial fora right now, which is to have these tests laid. That is why I asked for the fifth prayer, to issue orders to set up a review committee which will review all the orders passed in Beverly Hills and form a report on the same matter. When this prayer is asked, there is already a check mechanism on whether these orders are issued in the correct manner or not. Whereas in Anuradha Basheen, a review committee was issued for the past orders that were issued. It was for the orders that were put in place before the particular judgment came out, and that is why Anuradha Basheen wasn't able to give out a judgment which was useful for the state at that particular point of time, as it did not really take down these orders. If these orders were if these orders were taken down, there would have been a precedent as to what kind of orders need to be taken down. And I'm pretty sure by the narrative of the judgment that that such orders, such blanket bans of such a long time would have been taken down if they were produced before the court.
Okay. Thank you.
Much obliged.
So, Mr. Counsel, you want us to review all the orders that were there. Wouldn't that amount to judicial overreach?
Your Lordship,
all the orders passed is the subject of a stay. If you have a problem, you can come and challenge that order in the respective High Court or the Supreme Court. So why would you want us to review all the orders passed by the state?
Your Lordship, precedent has been already set in Anuradha Basheen where orders are being reviewed already. All I am asking is to not let this injustice continue in the name of vague terms like incitement of violence when it is not even taking place in the first place due to an overreaching ban that has been put in place by section 144. So when we are applying such blanket limitations on a particular state, it becomes the prerogative of judiciary to step in and see whether these orders that are being passed in the future are reasonable or not. And if your lordship is concerned with the fact that such reviews would lead to judicial overreach, the petitioner also submits that such a review committee be formed for a particular period of time so as to set some amount of precedent as to what kind of orders need to be passed. Right now, my concern is the petitioner's concern isn't with whether such orders should or should not be passed. It's the way they should be passed at least,
Okay,
and not imposing unlimited, blanket limitations on
Yes,
any state.
Mr. Counsel, we understand. We get your point.
Much obliged, Your Lordship. Any other questions from the Lordships?
No, it's fine. Respondent, you may please proceed.
Much obliged, Your Lordship. If Your Lordship's permit, may I begin with issue number 3, which is whether mere suspicion is enough to impose restrictions on movement under
Can you take
144?
us to the facts once more?
So the facts, as explained by the petitioner itself, state that on. Let me just come to the crux of the facts. On 13th of April, there were Article 370 revocation was initiated by the president, and it was subsequently revoked by the parliament, and post which a 144 order was imposed. On 12th April, there were internet restrictions which were placed in the state, amounting to a virtual communication blackout, as being stated by honorable petitioner. So these facts usually in totality form the crux of the case, and the rest of the facts I'll be referring to in my submissions. If your lordship permit me, I begin
Please
with
go
my
ahead.
submission. Much obliged, your lordship. On issue number 3, it is most respectfully submitted that a plain reading of section 144 reveals that it's a preventive measure and allows taking action on reasonable apprehension of danger. While answering the issue, your lordship, the word suspicion needs to be understood in light of requirements of section 144. Oxford Dictionary defines suspicion as a belief that something is true even though you have no proof. Your lordship, there are two kinds of suspicion now that can exist in this scenario. A suspicion which is based on conjectural premises, and the other suspicion which is based on past track record, well documented history of state. The first kind is surely ought to be rejected by this court, but the second, where due regard is paid to past track record, history of the state, propensity of inflaming passions, then this court must deem such suspicion as reasonable apprehension of danger as contemplated in section 144. Your lordship, in the case at hand, a reference made to the historical background of cross-border terrorism, infiltration of militants, secessionists challenge integrity of state, politicians making inflammatory remarks on subject of 370, such as no one in Kashmir will hold tricolor if Article 370 is tampered with, and if any hand tries to touch Article 35A, not only that hand, but the whole body will be burned to ashes, gives rise to a reasonable apprehension to any person, let alone a district magistrate, post the abrogation of Article 370. A holistic analysis of the above mentioned factors in lieu of abrogation of Article 370 reveals that had these restrictions not been imposed, it would have jeopardized the security of the state. As free movement would have led to a spree of violent episodes as a direct consequence of active participation of anti-India elements by giving cause for violence, public meetings by these fringe elements, which would have served as breeding ground for mobilization of anti-India front, which would have presented massive challenge to public order security of state. Your Lordship, this honorable court in Babulal Parathe versus State of Bombay, while determining constitutional validity of 144, held that anticipatory action to prevent disorder is within the constitutional protection under Article 19. The said ruling was also reiterated in Madhu Limaya versus State versus SDM, while holding that disturbance of public tranquility leads to subversion of public order, which is a reasonable restriction under Article 19, Clause 2. On the question of whether past track record is a valid criteria while formulation of a reasonable apprehension, it was held by this court in State of Karnataka versus Praveen Bhai Togadia that on the basis of past track record, necessary prohibition orders can be passed. Your Lordship, now moving on to the second issue, which is whether law and order situation justified communication blackout. It is respectfully submitted that restrictions imposed under Rule 2 of Suspension Rules 2017 is in interest of public order, security of state, sovereignty, and integrity of India. Your Lordship, this honorable court in PUCL versus Union of India held that Section 5(2) of Telegraph Act allows to impose restrictions if it's in interest of security, public order, sovereignty. Also in Anuradha Bhasin versus Union, it was held that order to be made in interest of aforementioned subject were termed as a prerequisite for exercise of power under Section 5, Clause 2 of Indian Telegraph Act and Suspension Rules 2. Your Lordship, it must be borne in mind that the state is under president rule, direct consequence of which is that the executive power of the government of Jammu and Kashmir rests with the president, that is effectively the Council of Ministers. Keeping that in mind, it is submitted, Your Lordship, that these restrictions were put in place at the instance of Union, as it appreciates the fact that subject of abrogation of Article 370 has been used to instigate people of hills to sabotage democratic functioning of state, making the restrictions imperative in light of protection of security of state and public order. On the question of whether these restrictions are necessary, Your Lordship, there are 4 points which suffice the requirement of necessity contemplated in Section 5(2) of Telegraph Act. Your Lordship, first, to prevent misinformation and spread of fake news which would have excited passions. Your Lordship, the nefarious impact of these fake news can be cited to an article which was written by Gregory McNeil, Professor of Law, stating, Internet posts can reflect any viewpoint, truthful or not. Streaming videos and frightening scenes can be used to support and magnify these fallacious viewpoints. These fake news websites and social media accounts carry out indoctrination of anti-India sentiments. And another trend, which is a very disturbing trend, which is the usage of deep fakes. Deep fakes as a technology, your lordship, most popular video was of Boris Johnson and Jeremy Corbyn, wherein Boris Johnson endorsed Jeremy Corbyn and vice versa doing Jeremy Corbyn. Was that fakely some statements are attributed to a person and it is made to look that that specific person is making that statement. So if that is being used for an important political personality in that day, it would have jeopardized the security situation of that state and led to a massive disservice to the public tranquility at that point of time. Second point, your lordship, to prevent cross-border terrorism and foil the plans by closing out links of communication which would render their efforts to garner support from secessionist elements, militant groups, local militant groups negatory. Third point, to avoid violence which would have been caused by provocation, circulation of provocative speeches by politicians and secessionists. As cited earlier, the kind of rhetoric that has been said by these elements is inherently dangerous. Last point, your lordship, to prevent access to dark web, which allows purchase of weapons and illegal substances, which was also appreciated by this court in Radha Bhasin versus Union of India. Your lordship, the last point, now responding to the contention that selective shutdowns could have been made, your lordship, it is humbly submitted that post Anuradha Bhasin judgment, where selective shutdowns were made, what happened that was that virtual private network, which is VPN, was used for accessing these banned websites, and those who were accused of using VPN and circumventing the rules were charged under UAPA, your lordship. So inherently, the petitioner has proved our point, made our point that selective shutdown is not a reality and it cannot occur in any circumstance, since VPN has been used in several times. In 2017, which selective shutdown imposed in Bihar and Kashmir was also circumvented by the use of VPNs, your lordship. Your lordship, lastly, coming to the reasonableness of restriction. Your lordship, there are two limbs to this argument. Your lordship, first, the council seeks to establish the test of reasonableness set out by this court and demonstrate that the restrictions are within the contours of reasonable restriction. The second point, your lordship, is the council would like to brief on the doctrine of proportionality and further would like to argue its inapplicability in the doctrinaire sense in matters of national security, your lordship. Your lordship, this honorable court in state of Madras versus V.G. Rao held that abstract standard of reasonableness cannot be laid down, while also holding that purpose of restrictions, extent and urgency of evil sought to be remedied and prevailing conditions at the time should be taken note of while deciding validity of such restrictions. In a number of judgments, your lordship, it has also been noted that restriction can also include complete prohibition. Your lordship, in Ghulam Abbas versus state of UP, it was also held that when there is conflict between public interest and private rights, the former must prevail. Applying the principles enunciated above, your lordship, keeping in mind that it can be reasonable, keeping in mind the circumstances mentioned earlier in the internet issue, it can be reasonably stated that issue of restriction on internet ought to be declared as constitutionally permissible by this honorable court. Your lordship, on the question of reasonableness of 144, the invocation of the said power post abrogation of Article 370 and circumstances discussed earlier made the imposition a necessity. Your lordship, this court's ruling in state of Karnataka versus Praveen Bhai Togadia is relevant. It was held that the court is not an appellate authority on 144 order and it won't intervene unless there is lack of jurisdiction, ulterior motive, malafide and extraneous consideration. Your lordship, what needs to be remembered while determining reasonableness is that magistrates are best equipped to know the on-ground situation, and right now the union is not very well equipped with the on-ground situation. Neither the petitioners are well informed with the on-ground situation. So a determination on that subject cannot be made since the lockdown has been imposed for 12 days only as of now. Your lordship, this point leads us to a larger discussion on whether proportionality can be applied to a measure for national security. Your lordship, this discussion emanates from the court's observation in Anuradha Bhasin versus Union of India, wherein it cautioned against the use of excessive utility of proportionality in matters of national security, sovereignty and integrity. Lordship, this point emanates from the understanding of this court that national security matters hugely rely upon apprehension, imponderables, and intelligence material. Direct consequence of which is that actions implemented by the state on many occasions is not the least restrictive one, and the need to interfere cannot be defined in a precise or a comprehensive manner due to reliance on intelligence material, your lordship. Lordship, in Rajkumar Singh versus state of Bihar, it was held that court cannot substitute its decision with decision taken by the executive if the grounds on which government is satisfied are such a rational human being can consider them connected in some manner with the objects which were to be prevented from being attained. Lordship, the question of satisfaction except on ground of malafide cannot be challenged in court according to Rajkumar Singh. Such observations were also echoed by this court in Union of India versus Salina and AK Call versus Union of India. Your Lordship, now moving on to my last issue, which is the first issue of the case, that the internet restriction. Your Lordship, we do not disagree that an Article 19(1)(a) and Article 19(1)(g) extends to right to internet. But Your Lordship, before contending on this issue, we would like to quote Mr. Winton G. Cerf, one of the fathers of internet, who argued that internet cannot be elevated to the status of a human right. Internet is enabler of rights and not a right in itself. Your Lordship, there is a need to distinguish between internet as a tool and internet as a medium of expression or a medium of travel or a medium of, or a medium of conducting business, Your Lordship. With the respondents fairly conceded freedom of speech over internet and carrying on trade over internet is constitutionally protected, but that does not have any bearing on the fact that internet, independent of any already recognized fundamental rights, is a fundamental right, hasn't been and cannot be a fundamental right, since stated earlier it can only be an enabler of rights, Your Lordship. Now with this, I conclude my submission, Your Lordship. Before, if there are any questions, or I can pronounce my prayer, Your Lordship.
Mr. Counsel,
Yes, sir.
there was a blanket communication ban. Did you
Yes, sir.
consider what is going to happen to the people who are physically unfit or those who have many medical problem? Their only means of contacting the authorities is through either phone or internet or something like that. What all
Your
precautions
Lordship,
have you put in place?
Your Lordship, in certain circumstances, in certain areas, Your Lordship, as was traced in various orders of the government, it was revealed that 2G services was allowed for some time, and also landline services for some areas, and postpaid services was allowed after subsequent, after reasonable, after, and it was revoked within some areas because it was a threat perception that was analyzed by the administration itself, and 2G services were relaxed for on that count, Your Lordship.
So what was your basic goal towards realizing this objective
Your
of,
Lordship, it
of
has,
imposing section 144? What was the rationality behind it? What was the connected purpose behind it?
Your Lordship, as stated in my first issue that I had argued, it was the rationale behind was simple, that if we allow free movement of these people, and let's say it can be said that necessary prohibitory orders can be passed against the prominent leaders. It can be said on account of that. But Your Lordship, a simple response would be that certainly recorded messages of these leaders can be played by their party workers, and there will be a scenario where it cannot be distinguished between the elements who are causing harm and the elements who are not causing harm, Your Lordship. So on that front, there was, and this distinction, this point has also been recognized by Madhu Limya versus SDM, which can be cited, Your Lordship. That was the essential rationale, and these public meetings or these calls for violence should not become a front for anti-India, Your Lordship. That was the inherent motive.
So on the part of communication blackdown, Mr. Counsel, explain me the rationale behind imposing a total communication ban. See, Mr. Counsel, in today's era, most of the consumption of your knowledge is through the digital medium. Now, most schools, most study material are available online.
Yes,
You
sir.
say that there is hate speech. First of all, tell me what are the effective measures that you have taken to curb hate speech? And the second
Lord,
issue is, tell me, if social media is in your control, why not ban all the social media sites through which the hate speech is being spread, and allow the rest of the services to continue on 2G or 3G?
very fair question. Very fair question, Your Lordship. As stated by the petitioner himself, that the subsequently social medias were banned, but that ban was circumvented by the use of virtual private network, which is VPN, Your Lordship. And many people, I'm not remembering the exact number, it was around 93 were booked under UAPA, and that was why we cannot impose a selective ban on social media. And Your Lordship, we understand that the Kashmiri people are facing trouble, but at the end of the day, Your Lordship,
Mr.
it has been
Counsel, it
held
is
by
not
various.
Kashmir.
Sorry, Your Lordship, Beverly Hills. Yes, sincere apology, Your Lordship. That Beverly Hills, people of Beverly Hills are facing hardship, Your Lordship, but it needs to be realized that it is based on a threat perception, and Your Lordship, catastrophe would have been much larger if these restrictions were not in place, Your Lordship.
But the issue of using VPN, is there any method or any way to block that? Any way to trace it?
No, Your Lordship, it has not been done as of now, Your Lordship.
So how did you come to identify that these people have used VPN?
Your Lordship, I'm not stating that people have used the VPN in our lockdown. I'm stating that previously when lockdowns have been held, when in previous manner, Your Lordship, in 2017, people circumvented through VPN, and it was according to reports by various news outlets which stated that people have used VPN as an option for accessing internet now, Your Lordship.
So you basically relied on the media reports to impose Section 144.
No, Your Lordship,
Or
we
complete
also relied on
communication
no, Your
blackout.
Lordship, no, Your Lordship, we also relied on the previous people who were booked under UAPA for offending the rules which were prescribed under Section 5 Clause 2 of Telegraph Act, and those were booked under UAPA, Your Lordship.
How did you
And
come
it
to
was
find
then,
out that those people used VPN? What was
Your
the method
Lordship,
of identifying that?
Your Lordship, Union of India found it. We, Republic of Avocado, did not
How? How
found.
did you find it?
Your Lordship, Union of India was able to trace that people were using VPN, and Republic of Avocado was not able to trace, Your Lordship. That's why we have
So
not
based on
been
the
able to
finding
trace
of
as of
Union of India, you invoked UAPA against the citizen.
we have, Your Lordship, we have not invoked that. That's what I'm saying. We have not invoked UAPA, Your Lordship. Union of India invoked. I'm citing Union of India as an example only, Your Lordship.
So based on what happened in Union of India, you were saying that you cannot impose complete. You did not particularly set this example of blocking several social media sites and allowing the rest of that, based on
Your
something which has
Lordship,
happened in a different country.
Your Lordship, it has happened in various countries like France, UK, and there are many examples that can be cited where VPN has been used to circumvent this link, Your Lordship, and it is based on the global experience of the administration that on that which has relied, Your Lordship.
So, Mr. Counsel, does that necessarily enable you to not show your bona fide by, blocking all those social media sites? Why
Your
did you have
Lordship,
to adopt such a measure of
Your
imposing a
Lordship,
complete blackout?
Your Lordship, since blocking of social media is not possible, there is no technology that has been existed that you can block some social media, and that ban won't be circumvented by the VPN. And there has been no technology as of now that can restrict the exercise of VPN unless you have a public ownership of VPN, which is existing in China. And Republic of Avocado does not have a public ownership of VPN, Your Lordship.
And what about the essential services? Are they still in
Your
place?
Lordship, essential services are working, Your Lordship.
So people can make call to their relatives, etc., etc.
Your Lordship,
Can they do that?
if they have landlines, or if they have postpaid connections, and also, Your Lordship, there have been internet kiosks that have been established. Internet kiosks have been established by the administration in certain areas in their DM's office, Your Lordship, wherein it allows the access of internet for certain urgent criteria, and it also allows for access of network connection, Your Lordship.
How many kayaks are there in your entire city?
Lordship, I don't have specific data at hand now. I can check and let you know about that.
And what is the total population of your city?
Your Lordship, I am not well aware with those facts.
Mr. Counsel, you are representing your state.
Your Lordship, I'm representing the Union, Republic of Avocado.
And does Beverly Hills not be a part of?
Yes, Your Lordship, it is a part, Your Lordship, but I'm not aware of the specific number.
Clearly shows the intention of delineating a state from the country and causing such chaos. To be extremely candid with you, Counsel, you should be at least aware of such issues. However, and I also feel the counsel of the respondent is slightly misguiding the judges, because para 2 of your moot problem clearly states that all mobile phones, landlines, connectivity, internet services are completely suspended. However, you seem to keep repeating that landline services were allowed and relatives can make calls to each other.
Your Lordship, it was allowed. Initially, they weren't allowed, but in later stages, it was allowed. And Your Lordship, since it has been...
Where are you getting? Can you please direct me in the moot problem where you're getting that fact?
Sir, let me direct you to the fact that, sir, I sincerely submit, Your Lordship, that it has been stated that all laws are pari materia to the Union of India, which would mean that all pari materia laws, which would also mean that exemptions granted by Union of India in the case of Jammu Kashmir will also follow in this case, Your Lordship.
It is not Jammu Kashmir.
Beverly Hills, Your Lordship. Sincere apologies.
Counsel, the laws are pari materia.
And Your Lordship, orders also are coming under the purview of laws. That's why the council is able to impeach them on the count of Article 19 and Article 21.
I completely deny that argument for the basis that you can only rely on the orders that are provided on the moot problem and the laws that have already been established in the Union of India, you do not have the right to take laws or orders or notifications that have been passed post that. You can rely on all the orders, notifications that have been previously passed.
Your Lordship, these notifications have been previously passed, Your Lordship. In 2019, landline services were enabled in the case of Union of India, and kiosk services were enabled in 2019 itself, Your Lordship. I can,
In
if you
India,
want
right?
to, yeah, yes, Your Lordship, but all laws are pari material to India, which means that restrictions will also be pari material to India, since they are advised under law, Your Lordship. I can also show the additional affidavit which was filed by the Union of India, which prescribed all these exemptions, Your Lordship.
All right. Now, my other question was, now you have caused a great amount of damage and losses to sectors like education institutions because they cannot access basic Wikipedia sites or sites for getting basic information. Anyway, the schools are shut because of your Section 144. So by you not allowing them to even access the internet for gaining education, you have stopped that sector. You have caused problems in the health sector when there's already a there is a massive rise
There's,
of, can you not hear me? Am I audible?
Your Lordship, there is some disturbance in your voice.
Is it fine now?
Yes, Your Lordship, go on.
Okay. I'll quickly re-summarize my question. First is you've caused damage to educational institutions because these students cannot access internet. Okay, he's off.
He's off.
Yeah.
Sincere apologies, Your Lordship. There was some issue with the network. Please
That's fine.
continue, Your
Is
Lordship.
it stable now?
Yes, Your Lordship, it's stable.
Okay. So my first point was you've caused immense amount of losses to educational institutions because students can't access the internet and anyway they're not allowed to go to school during the lockdown. Second issue is you've caused damage to health sector and there is a good amount of statistics which show there's a serious depression in the state of Jammu and Kashmir because of how the government has been treating the entire state. And thirdly, obviously the economy is well affected because small time manufacturers, the MSMEs, they cannot function when the entire state is in a lockdown. Now, the counsel for the petitioner kept relying on the balance of proportionality. Now, you have tried to reason it out by stating that there could be possible threats of violence, of terrorism, and the rest.
Yes,
Now,
Your
my
Lordship.
only question is, isn't it a clear lack of good governance and functionality of the Republic of Avocado to not be able to control this in the start as a whole, and now the damage or the brunt of it is being faced by the residents of Beverly Hills for no loss or for no reason of their own?
Your Lordship, first of all, on the point of proportionality, Your Lordship, the respondents also argued that the rule of proportionality should not be made applicable to such a in national security concerns, Your Lordship, which was argued in my last issue based on the
I
observations.
heard that, and I still believe the balance proportionality should be applied. Now, if you can take that into account and then give your answer, that will be really good for us.
Fair enough, Your Lordship. Your Lordship, then we need to understand that also the restrictions can also amount to a total prohibition, and it has been allowed by this honorable court in Dharamdat versus Union of India, Narendra Kumar versus Union of India, Your Lordship. And in certain circumstances, a complete prohibition is envisaged under the constitution itself. And the other point, Your Lordship, we simply cost to the people of Beverly Hills, but we still believe that the magnitude of problem would be much larger if these issues were not to be rectified by such restrictions which are being faced by this government itself, Your Lordship.
Okay.
Hello?
Yeah.
I don't have any
Is
more
his
questions.
connection still poor? I think he's still stuck. Anyway.
Hello? Your Lordship, am I audible?
Yes, you're audible now.
Your Lordship, so if Your Lordship if there are any other questions, then I may pronounce the prayer, Your Lordship.
Yes, please.
Much obliged, Your Lordship. Your Lordship, in light of the arguments In light of the questions presented, arguments advanced, and authority cited, the counsel on part of respondent requests this court to adjudge and declare that restrictions imposed in the Beverly Hills are reasonable and contemplated in the Constitutional Republic of Avocado, Your Lordship. So that will be all, Your Lordship.
Okay.
Much obliged, Your Lordship.
Your Lordship, are we provided the opportunity to rebut?
Your Lordship, it has been specified that rebuttal won't be provided in prelims. If
That
I
is
have
why
read the
that is why
There
I'm
is no rebuttal. There is no rebuttal.
okay, sir.
Okay.
Okay, sir.
much
Thank
obliged.
you
Yes.
so much.
Thank you, sir. Much obliged. It was an honor serving your court.
Thank you.
Likewise, Your Lordship, as stated by petitioner.
Good guys.
Yeah,
Hmm.
second guy is quite smart.
The
Extremely quick.
petition.
Extremely quick, the second guy. So you
Yeah,
didn't have a
extremely
chance
quick.
to hold him.
Ah.
Yeah.
The petitioner was a little bit slow, but he made good points. Had he had a little more
Yeah.
clarity, his points were
On the
really
law
good.
side, yeah.
On
Yeah.
the law side, his
I agree.
points were really good. So how are we
That's
marking them?
true.
Individually,
and-
or we are going to discuss it?
I have no issues, however you want. So I have given a rough marking to the speaker one. I'll just share my screen. You can just see that and accordingly probably take a call. Okay, now are you seeing the screen?
Mm-hmm.
So this is what I think is average for the first speaker. I don't think he could grasp the question and reply to it appropriately. His law was quite strong.
His law was nice.
Yeah, but I don't think his the ability to answer the question was that.
He was
good.
not very persuasive. The second one was a little bit persuasive.
Yeah,
And
but he
the
was
first
a
one-
little vague.
He
The
was
second,
a little vague.
yeah, he was just running with his own flow, and without actually waiting to check if we are convinced or have we even caught his point, which is quite important according to me.
He was just going on and on and on and on.
Yeah.
Not proper reasoning. Proper reasoning was not there.
Correct.
I've also marked him similarly.
Okay. Let me just.
8 out of 10 and this. Chalo, theek hai. I'll also jot it down and then I'll send it to Anas directly.
So we have to send our score sheet separately, right?
Ha.
Okay. Done.
Chalo. Very nice meeting you.
Chalo. You
Bye.
too. Take care, Chandan.
You
Bye
too.
bye.
Bye-bye.